Division Court Department, and all persons having business before this court will draw near to their tents and they shall be heard.
Thank you. Please be seated. The first case out for argument today is case 4, People v. Brown. Proceed, counsel.
Good morning. May it please the court. Krista Markarian for Angelo Brown. I will be focusing on point 1 of my brief. The trial court in this case erred in denying Batson relief where the people's reasoning was pretextual and the trial court did not make an adequate record for the denial.
Wasn't that an alternate juror, however, who never even deliberated?
It was an alternate jury, Your Honor, as this department has held that it is moot when an alternate juror does not participate in deliberations. I would note that the Supreme Court and the Court of Appeals has not directly ruled on this issue. There is currently a federal circuit split. The Sixth Circuit in United States v. Harris has held that this is not subject to a harmless error review under the federal doctrine of a structural error, that even if this alternate juror does not participate in deliberations, not only does this affect the defendant, it affects the jurors not selected and the integrity of the judicial system as a whole. And the protections under Batson are incredibly broad, which has been reiterated in the Court of Appeals of People v. Jenkins. In that case, it stated that under the Equal Protection Clause, these constitutional violation of the exclusion of any member of the race is solely on the basis of their race can affect the integrity of the judicial proceedings as a whole. It affects the community, the people's outlook under the Equal Protection Clause being such a violation that this is a trial error that impacts the entire trial as a whole and shouldn't be evaluated under the mootness doctrine.
So assuming it's not moot, getting back to your argument of the fact that the trial judge, I think your argument is, did not adequately establish a record with respect to the third factor, right?
Yes.
Right. So what did the trial judge have to do that the trial judge didn't do? I know that you, in your brief, you say, went right to the determination, said, I'm not going to grant it, and moved on. How elaborate did the judge have to be? In other words, what was missing?
Yes, Your Honor. The trial court is required to make an adequate record, and I would state that they have to make those reasonings as to why it wasn't pretextual, especially in a record such as this, where we have the people giving reasons for their reason of exclusion, that the trial court has to state why they did not find that pretext, at least at a minimum. Here we have the trial court.
So the trial judge would have had to, in this particular case, would have had to set forth in the record why the two jurors that were being you argue were equivalent, were not equivalent, and would have had established, at least in the court's mind, why the court was ruling, how it was ruling, and therefore would establish a better appellate review for us.
Yes, Your Honor. We do not know why the court even denied the Batson challenge in this case. It was I'm just denying the Batson challenge at this time. It makes it incredibly difficult for appellate to review. We don't know what the court used for that basis, especially given a Batson challenge. The case law is clear that must be some sort of adequate record made. None of that record was made, and therefore this court is able to either remit that for a hearing or reverse and grant Mr. Brown a new trial. And
Thank you.
If there are no further questions, I will rest on my brief.
Thank you, counsel.
Good morning, Your Honors, and may it please the court. I will start with the case People v. Thinero, which is a First Department case where leave was denied at the Court of Appeals. Defendant's challenge to the grant of People's reverse Batson, so it's a reverse Batson in this case, not third Batson, but the principle is the same. As to an alternate juror is moot since no alternates participated in the deliberation. They also ruled that it was specifically unpreserved because it was not specifically raised at trial. Defense counsel raises the argument that the court didn't say why the people's argument was not pretextual. The people say that the defendant did not preserve anything because the defense did not say why the people's argument was not pretextual, or excuse me, was pretextual. With regards to that, the people's argument with regards to why this particular juror, we call her AO in our brief, and CP, a white juror, was exactly the same, They moved for cause to get rid of these two jurors at first, based on the exact same reasons they provided when they went to strike them. Otherwise, when the for cause was denied. That's how this.
Counsel, let me just stop you for a second.
Yeah.
So assuming that we have to address the argument on mootness, I get that. But with respect to the argument, did the judge properly articulate the reasons in step 3? That's answer that question, because it seems to me what you're saying is there was the ability, because of the issues that were raised in the argument, for the judge to do that. But did the judge do that?
There was not an ability to that because the defendant didn't preserve anything. They made no arguments with regards to our case at all. So the people, I believe it's ADA Haggerty in this case, went and said, here's all of our reasons why this is not pretextual. You know, they were sympathetic. They said they have questions with regards to the justice system, so on and so forth. The court said, any response you wish to make to that? Mr. Gallagher said, no, Your Honor, I leave it up to you. So
You're saying in step 3, sorry to interrupt.
Please.
You're saying in step 3, the defendant has an obligation to set forth why the arguments that were just made by the prosecution are pretextual. They failed to do so, and therefore the court didn't have to articulate the reasons in step 3.
Absolutely, Your Honor. And
Okay.
also with regards to People v. Dandridge, which is a 2006 case from this department, that court implicitly determined the race-neutral reason to the prosecution provided was not pretextual. When the court said, I will deny the Batson challenge at this time, this court did the exact same thing the court did in Dandridge, and therefore we don't believe there was an error whatsoever. If this court doesn't have any questions, Your Honor, we'll restart the reading.
No further questions. Thank you, counsel.
Thank you.
Case number 5, People versus Brown. Proceed, counsel.
Good morning, Fabian Santacroce for Antoine Brown. My plan was to address all the points. I wouldn't normally do that, but I think they all are worthy of that. However, I wanted to give the court the opportunity to direct me to a specific point first if they would like me to.
Proceed as you planned.
Great. I believe the prosecutor's failure to disclose police disciplinary records was a violation of the discovery law and rendered the certificate of compliance improper. This court obviously has found in Sumler and Rojas Aponte that in essence, CPL 245 does not allow for a screening panel. This case does have a screening panel. Obviously, it is different than those cases because it's a murder trial. So we don't get to CPL 3030. So I suppose that the question becomes, well, what do we do? I think that after thinking about this a bit more, I think that it should be sent back and they should disclose those disciplinary records. And then if there is prejudice, they get a new trial, because that then takes us to belated disclosure, which would be 245-21K4. So send it back, give the what's missing, the actual records as opposed to just the summaries, and decide an appropriate remedy or sanction, which could be a new trial.
Finish your thought. Go ahead.
It could be a new trial. I think we can't ignore the, after the belated discoveries turn over, which I'm hoping that, the court, if this is the issue that you focus on, I believe there would be that next step of, well, what's the remedy or sanction? And
So my question is, Monroe County, from what I know, based on look at the records that we get on this issue, seems to be rather unique, at least as of some time, that they publish these law enforcement disciplinary records online in some fashion, correct?
that's correct.
And the summaries sort of dovetail here with those actual records, don't they, to some extent?
You're right. That's correct. And obviously the
Okay.
prosecutor's brief discussed that.
And as I read the statute, it looks to me like what is really pertinent here is as to the 3 testifying officers, right, who had a disciplinary record of some sort. Correct?
Exactly.
So far, so good?
Yes,
Okay. Now, as to those 3, however, according to the record, would you agree that none had substantiated?
that's correct.
And if I read the record and the transcript, it looks to me like defense counsel limited the request to substantiate it. That's what it looks to me in the record.
I suppose so. And obviously you could get to it in the interest of justice then. I think that in this case, obviously we did not, this case came down to the investigation of RPD. It didn't come down to any witnesses. And so their investigation put this case together, the circumstantial case together. You know, this person supplied the gun, this person drove the car, this one was the trigger man.
You want us to look beyond the limitation?
We don't, I suppose, yes. I don't know if this is my strongest argument, but I did want to address it in light of the fact that this court has decided in Sumler and Rodas Ponte. I didn't think it was something worth ignoring. Obviously, I will move on to point 2. I believe the trial court abused its discretion in allowing the prosecutor to introduce those 4 photographs of Mr. Brown and Mr. Scott with what appeared to be handguns. And I believe, in essence, it came down to they were relevant to show that defendants were together approximately 35 minutes after the homicide. And I believe the potential for prejudice to Mr. Brown far exceeded that probative value. We don't know if those were real handguns. We don't know if they had anything to do with the instant offense or were being used unlawfully. The DA argued in the Molyneux application that he thought he could prove continual possession. Then at the oral argument, obviously admitted, I can't prove that those were the same guns. And actually kind of proves my point that he wanted the jury to infer that one of these guns was the same gun.
Wasn't the prosecutor allowed to rebut the theory that the defense was promoting about the parties leaving the gas station separately?
I suppose so, but I think that 35-minute gap, I mean, we still don't know what happened in that 35 minutes. Obviously, the DA's position is that they were never not together, but there is that gap of time. So I understand the relevancy of that. Obviously, this redaction that I brought up, the defense did not ask for that, but the DA also didn't redact them. And if you look at these photos, it would be quite easy to just cut off the bottom and still show that these people were together at this party to make a music video 35 minutes after the homicide. And obviously, I think the DA talks about Mr. Brown's attorney not objecting to the limiting instruction. I will just note that he does say, we would like a limiting instruction, note our objection, which he's referring to allowing the photos in. As for point 3, I think applying either an abusive discretion standard or a de novo review, the judge's statements to the jurors had a chilling effect, which tainted the entire veneer. This was not preserved. However, I did cite to a First Department case that talks about the magnitude of the deprivation of defendant's right to a fair trial being a reason to use your interest of justice jurisdiction. I know the Nevada case is worse than ours. I'm not going to deny that, but I think I made out well in my brief. I'm not going to go through the facts. I'm not going to waste your time with that, but I went through a number of situations where the judge, his behavior, I think, deterred people from responding honestly. There were 2 times that I saw he chastised or scolded people and then asked people if they wanted to raise their hand to that same question. And on two occasions, no one rose their hand. He said something about making up things. He actually told the person, who was telling the truth, have you listened to anything I've said? And he said, the prospective juror said, yes, I'm being honest. You also told me to be honest. So while it's not as bad as in the Nevada case, obviously we do have rules governing judicial conduct. And I cited to 2 of those in my brief. And I think that I hope the court will look to this issue because he even penalized someone for asking to speak in private. He said, obviously, I don't know if the other jurors heard that, but he said that was his I don't know if it's a penalty, but that was the penalty he got for coming up here and wanting to speak in private about something that wasn't worth talking in private about, so I'm not going to go all through those things. I obviously covered them very in depth in my brief. But jury selection is how we, choose jurors. And if there is fear to tell the truth, we're not getting a fair jury. As for point 4, this goes to a 4 cars challenge for a woman who was married to an RPD officer of 32 years. I think what's important here is that RPD is the law enforcement agency that did the investigation in this case, made the arrest in this case. As I already mentioned, this case is based on their investigation, not per se on any witnesses. She gave a look to the defense when she said, I thought they would not want me. The judge did grant a challenge to someone else for saying, I believe. He also said he was going to circle back on that last comment of I believe, and he never did. But I think there's also a specific question she answered that, can you assure me that you will treat police officers' witnesses the same as civilian witnesses and not prejudge their credibility? And she responded, no. I think there's enough there. And, they should lean toward disqualifying when there's someone of dubious impartiality. And I think that was demonstrated here. I'm going to move on to the Batson claim. This is a situation where I believe Mr. Brown's attorney's initial challenge was not enough by itself to establish a prima facie case, but I believe Mr. Bryant's attorney joined and expanded upon that argument. Also, if this court finds that the attorneys did not articulate and develop all of the grounds supporting the Batson claim, you could reach this issue in the interest of justice. People v. Luke for First Department case. So this came down to African-American males. The defendants are African-American males. The two individuals being discussed, Mr. Wells and Mr. Dorsey, were African-American males, and there's a case, Hecker, that says that alone could be meeting your prima facie case. The first step is not intended to be onerous. The improper removal of just one individual of a cognizable group is enough. Obviously, I went into depth about, I believe the prosecutor and the judge did not understand the first step. They said that the fact the defense attorney used a challenge on an African-American was reason why this, we didn't make it past the first step. They also said that there were already Black individuals on the jury. The court then responded, I agree. We have people of color on the jury. That's not the standard. There's case law that says that's not the standard. It fell short of a meaningful inquiry. He exercised undue haste. Obviously, this case, in this issue, you would hold the case and reserve decision and remit, as opposed to the other jury issues, where my client would get a new trial.
Counsel, you should begin to wrap up. Your time is up.
And I just wanted to note that probably isn't good enough. That goes to point 6 of my brief. And Mr. Brown did receive the maximum 25 to life. His older co-defendants received 22 to life. Obviously, he was 17 years old at the time of this. Talk about raise the age and the Supreme Court and teenagers' brains and development. And he's also doing 28 and a half to life because of another case. And the timing of that is interesting because he pleads to that. And then a month later, they do charge him with a homicide that happened 3 months earlier. And of course, that must be run consecutive. So thank you so much. And I would also ask you to look at vacating the surcharge and fees, which is preserved by the defense attorney. Thank you.
Thank you, counsel.
Good morning, Your Honors. Ryan Ash for the people. As with counsel, I'll briefly address each issue, and if the judges would like me to direct my arguments to one, please let me know. Starting with issue number 1, I think that as acknowledged by counsel, there isn't a 30-30 argument here, but we still need to go into discovery arguments about whether the people were ready for trial. And really that's what ultimately the looking at whether or not the COC was valid is what the inquiry is based around. And I think most importantly, in my view, when I'm reading these arguments, is that these motion arguments happened, I believe, in March of 2023. Maybe it's 22. And the trial happened in January of the following year. And the people were disclosing these materials on multiple occasions. It's not as if this isn't a case where we have some discovery motion 8 months prior, and then on the eve of trial, there's a new batch of information that comes out. And I think, as counsel pointed to with Sumler, I think the use of those panels, obviously this court has come out with case law saying that the people cannot use a screening panel to determine what's relevant. Looking at this case, in my view, it is a lot different than other screening panel cases where the court maybe wasn't even given the opportunity to learn of the discovered material. And the people said, once it was found out, maybe on the eve of trial, that the material existed, the people said, oh yeah, we didn't turn that over, we didn't let you know about it because we determined it wasn't relevant. Here, there was a lot more dialogue going back and forth. And ultimately, I think when the people stuck by the court's ultimate decision on the discovery issue, I don't think that the defendant can show prejudice when the materials were relevant to witnesses who weren't called to that trial. And just very briefly on that again, I think the fact that the argument here is for a new trial as a remedy, ultimately, that's what was given to, that was the option presented when the discovery motion was made. Trial hadn't happened yet. And so I think that as a remedy for a discovery violation is kind of at odds with the procedural posture of this being an appeal. There needs to be an error where the remedy is something more than just doing the trial over again with the same exact evidence. I'll move on to point 2. I think the Molyneux issue here is tricky because there might have been a reference to this in the record, but the Molyneux application, in my view, is kind of out of an abundance of caution application, because Molyneux refers to non-charged conduct. And here, at the point that the Molyneux application is made, as counsel pointed out, the argument is that it is the same gun. So at that point, it's not clear to me how that is Molyneux evidence. That's identity evidence. If it's the same gun, that's directly relevant. It's only really turns into Molyneux evidence later when the argument actually changes. So I think it behooved the people, and they were, I think, correct to do so, to make this Molyneux application. And then when the arguments do eventually evolve and the court hears this, it's important to remember in context, there are other photos that are also put in the application, and the court denies those. And I think it's hard to argue that a court abuses discretion on an issue like this when the application is only granted in part and when the court weighed the appropriate factors. Going on to the jury selection issues, the comments during voir dire, in my opinion, were focused on the fairness of the trial. And I think that's really important. And at times, the judge did maybe even prematurely cut off some people before they were finished with their answers. But reading the record cold, once again, I wasn't there, and that's kind of the hard part, is I think that the judge's concern was whether or not the jury would take this seriously. This is a murder trial with 3 defendants. We need to have a jury who's here, who's impartial, and who's taking all the evidence in at face value. And I think it's a bad sign if the jury's not listening to every word of the court's questions. And ultimately, I might have answered, or I might have handled the jury's comments about not listening to the court's questions a little differently than this judge. But I don't think that we should be super opportunistic about jumping down on a judge who is, at the end of the day, wants to make sure this jury is paying attention and is listening to every word they say. And once again, there were comments, but they were spread out over several days of jury trial. This was a long jury selection. Going on to the 4-cause challenge, I think it's an interesting problem with the record, right? Because we're reading it word for word on a page. And here, there's, in my view, however many times this juror is asked, is your relationship with this police officer going to affect your ability to be impartial? She says the right thing. She says, oh, I was just assuming, yes, I can be fair, yes, I can be fair. And then there's that interesting question that comes up. And it's kind of it's a problem for 2 reasons. I think as a rule of evidence, it wouldn't come in because it's a 2-part question, but also it contains a double negative. The second part of the question is the double negative. And I think that my view of the record is that the judge ultimately realizes what was said and how the answer could be confusing. And that's why they followed up twice and said, you can be impartial. And the answer was yes. With the Batson challenge, the response was in the pattern framework because that's the way the argument was made. And I agree that, I'm not trying to argue at all that there has to be a pattern. That's not the case law. The case law is whether or not this is a race-based challenge. But we don't get to step two on every single challenge. Every time a Batson's challenge is made, you don't get to step two. Just saying, I'd like to make a Batson challenge for a pattern. That's not the facts here exactly, but that's not good enough to get you to step two. You have to give more than vague and conclusory allegations that we have a minority juror who was excluded. And here the burden isn't on the people to make a race neutral argument until step two is reached. And I think that's kind of the confusion with that, because a lot of times the Batson framework, it needs to be separate, but a lot of times I think when the court asks for the people to respond to step one, they do shoehorn in some step two arguments. And I don't think that happened here, but it's not error for the people to just
The prima
respond.
facie, step one prima facie demonstration is not supposed to be an onerous burden,
Right.
right? I mean, that it moves relatively quickly into step two is kind of a normal process here, right?
I think so. And I think what's kind of confusing normally is actually that I think step one is actually supposed to be just a dialogue between the defendant and the court. The people being asked to respond, I think, is what I'm talking about when I'm kind of saying that a lot of people compress these steps. And I think that's why our argument is based on a pattern here. Yeah, pattern wouldn't, saying, oh, there's no pattern, wouldn't be good enough to satisfy a step two argument. Sure. But I think when the court does open the dialogue up to the people, and the people do point out flaws in the defendant's argument from a logical perspective, I think that's okay. And I think that just because the dialogue involves all three parties in this circumstance, that doesn't mean that step one was automatically met just because there's an extended dialogue. Is kind of my argument. Thank you. And as far as weight of the evidence, I think the court has.
Let me slow you down on the weight.
Yes.
You might mention a little bit on this one. I watched oral argument last week in the Court of Appeals case for People v. Anderson. And one member of the court there seemed to suggest, or at least inquire about the case called Backey, and I'm going to mispronounce it, Bacque, that came out from the Court of Appeals in October of 2024, where it involved a circumstantial evidence case. Counselor, is this a circumstantial evidence only case?
No, I don't think so. And this is something that I think I have wrapped my brain around with constructive possession of a weapon cases or possession of a weapon where the evidence is constructive. And that's not exactly what's going on here. But there's a difference between direct and circumstantial, that's a separate analysis from constructive versus actual possession. And I think sometimes it's difficult to walk the brain through those separate analyses because constructive possession is about, do you have dominion and control over the space around it? Not, did you actually have it on your body? Whereas direct versus circumstantial evidence is about the amount of inferences that need to put the defendant either in possession of the murder weapon or doing the actual action or being at the scene. And here, in my opinion, the surveillance footage of the defendant and his co-defendants at the gas station, that's direct evidence. I don't think there's an identification issue. And so then when we have evidence that they're getting into a white Jeep and the white Jeep shows up to the scene of the shooting and someone gets out of the white Jeep and commits the shooting, those facts are closer to circumstantial evidence.
That's what I'm driving at, because in if this is circumstantial evidence only vis-a-vis the identity of the shooter, then that Backey case seems to say that in a circumstantial evidence only case, we have to rule out any other possibility of finding of guilt. So in other words, if we conclude, contrary to your argument, that a different verdict would not have been unreasonable, the point that was made at Anderson is if we say that and it's circumstantial evidence only, there's a possibility that means we must reverse, because we can't rule out any other possibility if we find a not guilty verdict would have been good. But you're saying we don't have that here, that we have direct evidence and we don't need to even consider that standard in Backey or the potential problem that Backey may be causing.
Yes, I would agree with your statement of the law, and I would also add on that in addition, in my weight of the evidence argument, I would argue that here a different verdict would not be reasonable. But if your recollection of those case law is, as you're representing to me, accurate, I think that's a logical line. But here, I would disagree that those facts, that this case shares facts with those cases.
Well, if that's a correct interpretation of Baki, one could argue that that's a sea change in the law. So I'm not saying that's the
Right.
law. That was part of the argument there. In any event, your argument here is that the evidence of the identity of the shooter is overwhelming, and therefore a different verdict would have been unreasonable, correct?
Correct.
Great, thank you.
Thank you.
Thank you, counsel. Case 6-7 in the matter of Hannah Lease. Counsel Whiteside, can you hear us?
I can hear you now.
And we can hear you. Counsel Gray?
Yes, I can hear you, Your Honor.
Very good. Let's proceed.
Good morning, Your Honors. May it please the court. I believe the issue here is fairly straightforward, issue of statutory interpretation. Our position is that the orders of protection issued in this case are not authorized by the statute that was applied in this case, and that the matter should be sent back down.
Mr. Hobbs, you've made a very interesting argument from my perspective on appeal. My problem is I don't think your interesting argument was made below. Is that a fair statement?
The objection, there was a general, yes, I believe it. There was a general objection that, or the issue was certainly litigated. The parties recognized that there is this blood relative requirement or exclusion in the statute, and the DHS cited to the Clinton County family court case, which I've distinguished in my briefs. And so the court had to reach the position that that reasoning or that court case authorized these orders of protection. In any case, I believe it's a jurisdictional issue in the sense that the statute defines what the court's power is, and if this is outside of the scope of the court's power to do this.
It's an interesting argument. We'll take a hard look at it.
Okay. Are there any questions on the merits of the?
No questions, Counsel.
Then I'll rest.
Thank you. Counsel, proceed.
Thank you, Your Honor. Mary Whiteside for the Monroe County Department of Human Services. We would ask this court to affirm the orders of protection in both of these cases. There is no legal relationship, no right or of this appellant to contact either of these two. I'm gonna distinguish. There's a former stepdaughter, and then there's the two biological children. So as far as the former stepdaughter, there's obviously no household relationship, and her mother, while the appellant and her mother are still legally married, her mother surrendered her parental rights. So there is no legal relationship between them, and the parents, while legally married, are not actually together and haven't been together for quite, functionally are not together. And so I'll let AFC Gray, handle that, but we think that that is a pretty clear argument. I would like to address the fact that the two biological children do not have an AFC here. And I would like the court to note that the trial AFC vigorously supported this order of protection. This appellant really has no relationship with the biological children, never lived with them, never parented them, has never even been allowed to be alone with them. Dangerousness, I think, is all over this case in terms of, this father's history and his progress or lack thereof through sex offender treatment. So we feel that we've definitely established dangerousness, definitely established a continued desire and request to have contact and no legal authority to do that. So to think that family court doesn't have the ability to protect children in this circumstance, I think that they absolutely do. And there is no legal right for this appellant to have contact with these children anymore. If there's any other questions, I'd be happy to address them.
Thank you, counsel. Counsel Gray?
Thank you, Your Honors. I've been appointed to represent Hannah-Lise, and Hannah-Lise is 15 years old, and she's been living in a relative foster care placement for quite some time now. As Counsel Whiteside said, I don't believe there's any legal relationship between my client and actually the perpetrator of her abuse. The mother surrendered her parental rights, even though she may still be legally married to the appellant. The appellant never adopted her, and there's case law that makes that distinction that's cited in my brief. And so, in short, there is absolutely no legitimate reason that I can see for the appellant to try to contact my client, and I believe she needs to be protected from him. If there are no further questions, thank you.
Thank you, counsel. Case number 8, Marina versus Merritt. May it please the court. Are all three counsel arguing?
I am.
Right? All three are arguing, right?
I'm the attorney for the child.
Yes. So why don't you sit up here, sir? Yep. Just like to know who the players are and who we can expect to hear from. Wonderful. Thank you.
Good morning.
Counsel, proceed.
Peter DiGiorgio for the appellant. This is an appeal of a custody modification matter, and there's also a cross appeal. I'm going to primarily rely on my brief for a majority of the points, but I want to start backwards on an issue that come up on the cross appeal. The cross appellant seems to assert that by nature of the fact that both parties petitioned for sole custody and the court ultimately found that there was a deprivation of visitation that kind of automatically blossoms into an award of sole custody when the parties can't communicate or engage one another. I may concede that both parties petitioning for sole custody may constitute a change in circumstances, but ultimately the court has to award an order that's in the best interest of the child. I akin it to if both parties petition to say the other party should have no contact or supervised contact, and after the court hears all the testimony, determines that both parties should have contact, the fact that they merely petitioned for that relief is not the be all end all. So to get to the meat of this case, this is an interesting case from reading the decision in that a large majority of the findings chastised both parents. And from the appellant's point of view, it seems like the less culpable parent got the reward of getting some decision-making authority in primary physical custody. And I want to talk about why we assert.
Is that an unusual situation? I mean, sometimes the courts, the family courts are stuck with very difficult decisions to make. And we see them even a lot more difficult in cases like this. You don't always have two perfect parents that you're dealing with, and you're sometimes balancing these. And it sounds to me like you're being critical of the judge for having done that, but that's what the judge does, right? That's the job.
In some respect, Your Honor, but I think you got to be cautious here. Just because there's bad parental behavior doesn't necessarily mean you have to modify the order. That's what violation petitions are for. So I can envision a situation where you have bad parental behavior that has to be punished. It doesn't always mean you have to modify a custody and visitation order. The court even noted that neither parent in this application filed a violation petition. So here we got days and days and days of testimony of hearing bad parental conduct on the part of both parents. And then the court looks at it, says, I have to do something. This is horrific. And ultimately then, tweaks the custody, the legal custody award and changes over physical custody, and then also gives decision-making authority. I think there's got to be a correlation between how is that fitting the best interests of the child. The court made two very specific findings on behalf of my client.
When the court, you just referenced the decision-making authority change, was that, that wasn't a complete decision-making authority. It was a tailored decision-making authority, right? Relative to educational?
Educational and counseling was
Yeah.
the two areas.
Yeah.
But how did that, and reading the decision, how did that correlate? The mother had done a lot of looking into schools, educating herself. There was no proof of what the father had done in that respect. With respect to the counselor, the mother sought out the counselor and did all these things, and yet she took away authority. And I think the basis for her taking away the authority was pigeonholed because the mother deprived the father of those 11 or 12 or whatever number of days of visitation in January. And
Also, in fairness, she also made a decision to send the child to a specific school without consulting the father. That seemed to be a fairly big factor.
I think that was questionable in the proof, and I'm not sure exactly what the court made as a finding, whether it was discussed, but certainly the child had been in the Catholic school for a significant period of time without objection, without a petition, without him contacting her saying, what are you doing? He even picked up and dropped off from that school. The two important findings the court did make, and this is why I characterized in my brief, this is, whoever is the less culpable parent loses here. The court found that the mother was the primary caretaker and had valuable information to import. She was the hands-on one. Now, I know the court and certainly the respondent criticized her for this allergy to dairy. She may have been overprotective, but being overprotective doesn't make you a bad mother. There was plenty of testimony. The court didn't make findings in this regard, but there was plenty of testimony about all these injuries that are happening, bruises, cuts, scrapes, that caused the mother to overreact. And even the visitations in January that she was deprived, it started because the father didn't contact her and tell her the grandfather was going to be picking up. They had to agree. It was in the court order that there had to be a third party, had to be upon agreement. And she was worried because it was 5:30 or 6:30 in the morning or whatever the child was being picked up, that the child was going to be watched by the new wife or the fiance, I believe at the time. Now, is that conduct?
Before you get deeper into this, do you have a current proceeding in family court with the same judge and these same parties and currently going on right now?
We do. I'm not the trial lawyer on that. I'm only the appellate attorney. There is something actively ongoing. It's in the second or third day of trial. I believe it's Mr. Macrina's petition, and Mr. Atkinson or Mr. Bleckley are actively involved in that. I believe they can update you on that if you're interested. But I believe Mr. Macrina has a petition for sole custody, and it's being litigated right now. And there may have been another petition recently filed.
But in your view, it does not affect this appeal? You don't feel that?
Right now, it does. Right now, it does not. I think if the parties entered into a consent order that superseded this order, that it would moot out this appeal if ultimately that happened. But it depends on
Counsel, of course, is aware of the importance of making us aware of that, should that happen.
Yeah, I am. Yeah.
Not just you.
No, and I do that routinely, but I wait for the actual court order, because for all intents and purposes, those
Understood.
proceedings could have been
Understood.
dismissed. So just in summary, yeah, was my client making the best judgments? Probably not. But I think we got to tie it into the best interests. The second finding, the first finding was the mother was the primary caretaker. The judge made that finding and had valuable information. She was the hands-on parent. So taking away this, in the cross appeal, joint custody and taking away decision-making authority certainly wasn't in the best interest of the child. And then she said blocking the mother from decision-making would strain the relationship and have an adverse effect. So the court even is making a finding that taking away this certain decision-making authority could have an adverse effect. I submit the court should maintain joint legal custody, restore it so both parties are participating in all decision-makers authority, and also look at, should she have switched over the primary physical custody? It didn't make a big, huge difference because the number of days, it was almost equal to start off with. But again, it goes back to my theme, at least I asserted in my brief, that there was bad parental conduct. It weighed against my client that she was the more culpable one. We had to do something. Or if this was a violation petition, keep the order the same and fine my client if you found she violated the order. Fine her $500 or whatever. That's the better way to handle it than to tie it in with custody and legal custody. We should always be looking at the best interests of the child.
We'll take a look at that, counsel.
Thank you.
Thank you.
I'd like to address Thomas Atkinson, counsel for Nicholas Macrina, appellant and cross appellant. Your Honor, there is a petition pending. Learned the counsel is incorrect. It's the result of mom's petition, and my client filed a cross petition. So the trial that's pending now, I am trial counsel for both, results from the petition she filed. Ultimately withdrew on my motion, but the trial is pending. The third day is next month. In many ways, this is a simple case. This is the judge's decision. Ms. Merritt had grave difficulty in answering questions that were not asked, preferring to stand upon a soapbox and provide the narrative she wished this court to hear. Predictably, Ms. Merritt overemphasized Mr. Merritt's faults. Unfortunately, she also seemed to be completely devoid of any awareness of her own. She accuses Mr. Merritt of being unwilling to communicate, unwilling to listen, insist upon doing it his way, and ultimately failing to put Colton's needs first. All of which she is guilty of. That's a direct quote. All of which she is guilty of. The dysfunctionality between the two parents is astounding. Direct quote. How in the world is that consistent with joint custody? What happened here was this. This was not a case where they were both guilty. There were 11 police reports. She filed every single one for 11 times. Simply because grandfather came to pick up the boy, because my guy's work schedule changed. He's a plumber. He's building the Wynn Hospital. To move it up, they started him at 6 o'clock in the morning instead of 8 o'clock. This is important. The grandfather gave this woman a home, grandmother, grandfather, paternal grandparents, gave the mom a home for 6 months when she was at odds with her parents. Got along beautifully with the grandparents, okay? All he did was pick up the child at her home because my client was working so he could go to school. 11 police reports. Three CPS reports filed because of mom's
All of
conduct.
this was the subject of an exhaustive amount of testimony.
Absolutely,
Of course,
Judge.
About 11 days, resulting in a 20-page decision by the court.
Absolutely.
Where the court was very particular, as I read the decision, about trying to explain why, despite the acrimony between the parties, it was going to maintain joint custody for the reasons that it would be in the best interest of this child to maintain that joint custody. The court gave very specific thought to that concept and that topic. So why shouldn't we respect that?
I think it's an error of law, and here's why. The judge said, and I quote, the large reason, and I quote, that she did not give dad sole custody is because he smirked and rolled his eyes during mom's testimony. He's facing police reports 11 times. He goes to the hospital to have a visit with the son. Mom says, leave or I'll call security. Three CPS reports. The little boy is swimming at grandma's house. Mom calls. 10 minutes later, 2 state police troopers arrive. Get the kid out of the pool. The next day, she took him for chest x-rays. He's swimming in a pool.
But Counselor, all these particular facts.
Yes, sir.
Were considered by the court, and the court reasoned that it's going to maintain, albeit unusual perhaps, maintain joint legal custody because the mother had been the primary caretaker since the birth of the child, right?
Correct.
And also the making a big change might have impacted the relationship even more negatively between the parents, and therefore would not be in the best interest of the child. Isn't that a good reason to act here the way the court did?
No, I'll tell you why. With all due respect, you asked an appropriate question. The decision gave dad certain authority. He needs sole custody. They both asked for it in their submissions, in their trial, and in their post-trial briefs. All right. Mom takes the kid to a doctor constantly. We had hundreds and this many pages of medical reports. I'm not exaggerating. A foot. Mom testified constantly the kid had dairy allergies, wanted medical tests, wanted hospitalizations. There was not one trace of evidence from anyone to a dairy allergy. Mom has got to be stopped in plain English. Dad took the boy for a haircut. He brings the boy back to mom. Mom falls to her knees, sobs, crying, saying, "Don't worry, baby, it'll be okay," and says, "You have crossed personal boundaries." He took the kid for a haircut. I put in pictures of the haircut. Little smiling little boy, 7-year-old in a barbershop. Mom has got to be stopped. Dad teaching about how to ride a bike. He falls, gets a little scrape. Hospital, CPS report. There were hundreds of photographs that were astoundingly minor. The kid had a mosquito bite. He took it to urgent care. He had a mosquito bite. And this happened constantly. Now, January, 11 days, he doesn't see the kid. She blocks his phone calls. For the month of January 2022, which is why we're here, she totally blocks his contact with the kid. This 7-year-old doesn't know why dad's not calling, doesn't know why dad's not coming. This 7-year-old saw the police in uniform cars and uniform outfits questioning his mother, questioning grandpa. All he did was pick up the kid. The Bassett Hospital thing is critical. He's at the doctor's for an appointment that we don't know about. My client doesn't know about. My guy finds out through the portal. He goes to the hospital. She says, "Leave or I'll call security." He left. And this happened time and time again. Great respect for the court. Great respect to her findings. She made an error as a matter of law. Remember, she said the dysfunctional is astounding. Yes, sir.
Counsel?
Yes, sir.
We have the record. We have all the information you're citing to. We'll take a hard look at that.
Thank you, Judge.
Good morning, Scott Palicki, attorney for the child. I don't believe I cited in matter of Michael B. The Court of Appeals in 1992 said that change of circumstances need to be considered by the appellate court. I think that was your direction, Your Honor, that we should keep the court updated as to what takes place, I think, both legally and factually. My client is 8 years old. He is halfway through the 3rd grade. He's in his 2nd school. He is much improved. When this case started, he had a great deal of difficulty sitting still and communicating. He had serious issues at Notre Dame where he was going to school. The school was very concerned. I'd probably seen him there more than I'd seen any client over the last 4 years. I talked to him in December. He's doing very well in his new school. He likes the arrangement as it is with his parents. He believes it's fair that he sees both his mother and his father as he wishes. And I do take some issue, although I agree personally with many of Attorney Atkinson's characterizations. My client has to live with his mother and his father. Punishing his mother for what she's done excessively isn't in his best interest. It's in his best interest for his parents to find some way to get along and to parent him. And although they are back in court and we do have a 3rd day of trial again, and we'll see where that takes us. He is much improved. He is doing well in school. He's playing sports.
And that was your recommendation to the court as I read your conclusory statement to the court. That is, it's broke, it's got to be fixed. And now it looks like it's kind of fixed for the moment. So you're asking us to affirm.
Correct. That's exactly it. I won't waste any more of your time. Thank you very much.
Thank you, counsel. Case number 10, Pryor versus Liberty Resources, Inc.
May it please the court. This is Tim McMahon from Bond, Shonick and King, representing the named defendants in this lawsuit. Your Honor, as I understand, you have a lengthy record here. You have some extensive briefing with an appeal and a cross appeal, both emanating from a motion and a cross motion. I think I'll start in the order of my arguments below and carry those over on appeal to here. Your Honor, we have a purported 2004 agreement, okay, allegedly signed on February 1st, 2004, although the record is a little unclear on whether or not that's 2004 or 2006. Regardless, that agreement was executed between Kim Pryor and Liberty Resources, a Delaware corporation. This lawsuit was commenced against, it was commenced by the estate for Kim Pryor against several entities, none of which are Liberty Resources, a Delaware corporation. We believe that provision in the contract is clear and unambiguous and should be enforced that way, resulting in the dismissal of this lawsuit
It's not a
against.
Delaware corporation, is there?
It's not a Delaware corporation, correct?
But it never was.
And it never was.
There's
Correct.
a lot of differing testimony regarding whether this is a New York corporation or whether they meant it to be a Delaware corporation, and there seems to be a lot of questions of fact.
Correct, Your Honor. And let me take a step back from that. Certainly, the plaintiff has pointed to certain portions of the contract, right, to show that maybe the intent was New York as opposed to Delaware, or maybe this was a typographical error. And under those circumstances, when we have that ambiguity, and I submit to Your Honors that we don't have that ambiguity, but when we do, the parole evidence has to decide that intent. Did Liberty Resources, did Kim Pryor mean Delaware, or did they mean New York? And in my view, the overwhelming record evidence, as a matter of fact, all of the record evidence points that that intent was Delaware. And why is that? There was a whole-scale corporate restructuring going on at this time period, right? And that testimony is shown by the CEO, Carl Coyle. Carl Coyle submitted some documentary evidence regarding some board meeting minutes from this time. Liberty Resources retained a gentleman named Elliot Green. As a matter of fact, Kim Pryor was present at these restructuring meetings. And so the intent, there's only one side to the evidence in this case regarding intent. And that is that Liberty Resources intended to be a Delaware corporation. At the time this agreement, I'll call it an agreement to agree, was entered into, it was intended that Liberty Resources and all of its entities would be a Delaware corporation. So in light of the fact that this lawsuit was not commenced against any of the named defendants in this lawsuit, we request dismissal on that ground. That, of course, is not the only ground that we seek dismissal on. The second ground stems from our position regarding validity and enforceability. That being that the executive plan agreement at issue here does not include all the material terms, all the essential terms, making it indefinite. What we're missing.
The Schedule A referring to.
Correct, that's Schedule A.
Then again, there's so many issues of fact here. There's conflicting testimony whether or not that Schedule A was attached or was not attached.
Your Honor, I submit respectfully that the only witness in this case that has anything to say substantively about the existence of Schedule A is Michael Sales, okay? And if we look past the idea that parole evidence cannot be used to, can only be used to connect the papers as opposed to establish missing terms, I think the crucial issue with the lack of a Schedule A is the statute of frauds. Okay, I think the case law in New York is clear that we cannot use parole evidence to circumvent and to overcome the statute of frauds. Okay, and that's supported by the Telco case in the 3rd Department, the Court of Appeals in Basic, the 1st Department in DeRosas, and the 2nd Department in Delfino. Now, this court.
It's a Nicosia.
Yeah, Nicosia is my pronunciation, but you probably have it better, Your Honor.
I don't think so. I mispronounce names all the time. I forget your name too, so go ahead.
Nicosia, in my view, is a limited carve-out. Okay, and what Nicosia told us was an attorney who drafted the agreement, sat with the folks, personally observed them sign it, and testified in a deposition and put in an affidavit the details of that agreement. Okay, and I think this court correctly found under those circumstances, those very, very limited circumstances here, because this is crucial, right? Because otherwise, an oral agreement can't be saved by anything. We need to have that in writing subscribed by the parties. So Nicosia says that's okay if we hit those elements. But let's take a look at what Michael Sales did. Michael Sales, in this case, never saw Kim Pryor's final agreement. Okay, didn't know when it was executed. That's crucial here, because if he says 2005, then we're measuring what her salary was in 2005 to determine what 60% is for the 15-year benefit. So is it 2003? Is it 2007? He couldn't tell us. All right. He didn't know exactly what the monthly benefit was. He didn't know if Schedule A listed a monthly or an annual benefit. I'm not trying to be hyper technical here. Okay. His affidavit says one thing, his testimony says another. The crucial point I want to make with that discrepancy is, as I questioned him during that deposition, and I encouraged the panel to look at that deposition testimony, he ended up throwing up his hands and said, I don't know. It was 20 years ago.
Is your argument, maybe it's not this simple, so forgive me if I'm oversimplifying it. Is your argument, there's no Exhibit A attached to this, end of story? That's a material term. Plaintiff loses.
Correct.
Okay. What if there are questions of fact as to whether there was at some point an Exhibit A attached to this agreement?
Then we get into the statute of frauds, Your Honor. Because at that point, can we take parole evidence and install those material terms? That's a statute of frauds problem that I don't believe the plaintiff can get over. Now, that sounds harsh, okay? And that's where we get into promissory estoppel. My view, promissory estoppel was not raised before the court below in the pleadings or in motion practice.
So anytime an attachment to an agreement is lost, assuming it contains a material term, ball game's over.
That's what Tulco out of the third department said, Your Honor. And Tulco was referenced by DeRosis in the first department and fully supported by the Court of Appeals in Basing. Okay. The third issue under the umbrella of validity and enforceability is what I would call contractual formalities. Okay. In New York State, we're free to enter into a contract as we see fit, so long as it's legally permissible. Okay. And some of those contracts may have certain formalities, right? The parties sign them, notarize them, or, just the parties sign. In this case, this contract required the signature of an executive, the CEO, Carl Coyle, the executive, Kim Pryor, a witness, and a secretary. Okay, I submit we're missing two of those signatures. That's lacking the contractual formalities.
What do you base that on when you say they required that? Simply because there's signature lines on the agreement?
I submit that.
That's enough to say that therefore those signatures are required?
Your Honor, and I say that primarily because who we're dealing with here. We're dealing with two sophisticated parties. This agreement was between the CFO, right, and Liberty Resources. These are two sophisticated executives. They see the agreement, and there's a backdrop here, right? There's the Delaware backdrop here, knowing, right, that this wasn't final. In essence, what I'm saying, Your Honor, is this was an agreement to agree, okay? And by not having those signatures, that's further evidence that there was more to come, and this wasn't a final and binding contractual arrangement.
It's basically in the jurat, right?
Yeah.
But let me take you back. Isn't there a split in authority, though? You said, and there is the third department case you referred, but doesn't the first department go the opposite way on the use of extrinsic evidence?
Your Honor, it's not to say there aren't first department cases that have a Nicosia case, but as I read the first department in DeRosis, I see support for the idea for the default principle. The default principle being that parole evidence cannot be used to create a missing term or to provide a missing term in a contract.
Okay, but I'm referring specifically to the equitable. Plaintiff is able to prove the extrinsic evidence of the application by its delivery by parole and circumstantial evidence.
Okay. Your Honor, I certainly will look at that case. I will submit that the Court of Appeals endorses the same principle. And I think every department has struggled with this issue. That being that if we have an individual like in Nicosia who can testify in detail exactly what that agreement said, that individual in Nicosia was an attorney. He drafted the agreement. He sat with the folks. He saw them personally execute the agreement. I think what this court said, rightfully so, is what else do you need? We can allow for that. But I do think the third department's default rule is consistent with what the Court of Appeals says is that we can, otherwise, Your Honor, we'd be allowing, right? We'd be allowing an oral agreement by itself to satisfy the statute of frauds, in my view.
Counsel, you should be mindful of your time.
I am. Yes, Your Honor. I apologize. The last point I make, and in order to get to this point, we've gone through the Delaware issue. We've gone through the validity issue, that being lack of essential terms, statute of frauds, required signatures. We get to the issue of a condition precedent. Okay. And here, Your Honors, the contract clearly required a claim be filed with the plan administrator 60 days after a payment was not made. That did not happen. Ms. Pryor executed this agreement in 2004. She passed away, unfortunately, in 2016. We were advised for the very first time that Mr. Pryor sought a claim under this agreement in 2021. Your decisions in both Acadia and DNM say failure to follow these claim procedures result in dismissal. And I just want to take a moment to go through three arguments that I think plaintiff's counsel will touch upon, and that is corporation by estoppel, promissory estoppel, and spoliation. All of those are unpreserved. None of those were raised below. In addition, corporation by estoppel applies only when a defendant seeks to escape liability to a corporate plaintiff by contending that the plaintiff is not a lawful entity. We're not saying that here. We're saying that the defendants are the wrong parties. They were not parties to this contract. Promissory estoppel, I urge the court to look at the Court of Appeals case in Hennel. This is not plain vanilla promissory estoppel. This is promissory estoppel plus an unconscionable injury. Okay. And so what we can't have a situation where the court just says, this seems unfair, right? This seems unfair, so they should be estopped from contending that we don't have a full and final and complete agreement. Your Honors, here we don't have a clear and unambiguous promise in any event. We don't know what the amount was. We don't have detrimental reliance because we have no record evidence that Ms. Pryor changed her lifestyle, changed her retirement outlook, or turned down other jobs because she had this executive plan agreement. But most importantly, Your Honor, promissory estoppel fails here because of the lack of unconscionability. Something that flows naturally from the breach of contract is not an unconscionable injury. And finally, spoliation. Again, not preserved. Our contention is that Schedule A never existed in its final form. And I need to point out the factual, the undisputed factual point here is that this case was heavily litigated, extensive discovery. Two executives, both Michael Sales and Elizabeth Nolan, neither of them could produce a Schedule A. Two attorneys, longstanding attorneys in Central New York working for Liberty Resources, neither of them could produce a Schedule A. Okay, so nobody in this case on both sides, plaintiff side, defense side, nobody could produce a Schedule A. Spoliation is, in our view, entirely inappropriate. Thank you for the time this morning.
Thank you, Judge.
Morning, Michael Kenny, on behalf of the estate of Kim Pryor. I am both the respondent and the appellant since there were dual motions in the lower court. One thing I will say relative to the lower court's decision is I would quote what Judge Gilbert said. This agreement is no model of clarity. And it is clear that it isn't, right? And what does that mean? It means that this agreement was unclear and ambiguous just based on the very terms, right? Let's talk about the New York versus Delaware to start, right? What we know is we know that, in quoting my esteemed counsel, these were sophisticated people, right? And Carl Coyle, who was the CEO of Liberty Resources of New York, comes in and signs that agreement on behalf of Liberty Resources of New York, right? And Kim Pryor.
He never objected to not signing this agreement, right?
Of course, no, they did not, right? And Kim Pryor was never an employee of Liberty Resources of Delaware, right? And her start date that was set forth in the executive plan agreement was exactly the start date that she was with Liberty Resource of New York. And we all know that, right? And the interesting part is, if you look through the various aspects of the agreement itself, if there's a dispute, and we asked them if they had this, right? If there was a dispute and they were going to revoke that agreement, that had to be in writing. And who did it have to go in writing to? It had to go in writing to Carl Coyle, and it gave their James Street address or their New York address. It wasn't anything relative to Delaware. It's our contention that Delaware has no relevance at all here, because what we want to look at is we want to look at the intent of the parties, right? Was there an offer? Was there an acceptance? Was there consideration? And was there capacity to enter that agreement, right? The offer was clear. They spent a lot of time, and you can look through the record, and they spent a lot of time, meaning Liberty Resources of New York, time and resources to develop this supplemental executive plan agreement, as well as what Mr. McMahon didn't talk about is the trust agreement that Mr. Curtin utilized to engulf these executive plan agreements, right? And by the way, just as a side point on that, there was no secretary line, and there was no need for a seal on that. So I think we were talking about the same thing. So what we have is whether there was an offer, they spent all this time and resources in developing this plan, whether there was an acceptance. The acceptance has a couple of parts to it, right? Was this Schedule A attached? Well, we have testimony in the record, and I would say that it's an informal judicial admission by Michael Sales. He was the president of the board of directors at the time that this took place. What his situation is now is really irrelevant, because what we're looking for is we're looking at what happened at the time. What was the intent of the parties at the time? And Michael Sales says it, right? He goes, I was the one. We made Schedule A. I know Schedule A existed. Whether and the only other thing we do know is that Liberty Resources was the last group to have this original executive plan agreement for Kim.
So again, we're back to, there are so many questions of fact here, though, on both sides. There are two very different stories being told, and it hasn't gotten to the gist of it yet.
Yeah.
So,
Your Honor, to abandon part of my move for summary judgment, I acknowledge some of these issues are very tricky. They really are. And Judge Gilbert, to know some of the history, he was in from the very beginning. From the very beginning, they said that there was no such agreement, right? We made a motion for pre-action discovery. No, this doesn't exist. Oh, and then they said, oh, but there's no executed agreement. So they're changing their tune every time. And then when we show them the executed agreement that they found in a safety deposit box with some other deeds and things like that, things that people keep in a safe place because they want them, right? Now it's relative to enforceability. Now they're talking about the enforceability of this, right? So the interesting part about Schedule A, though, because I do want to address that, right? We have a reasonably objectionable means to determine what Schedule A was. And what is that? That's in Michael Sales' testimony. Now,
doesn't Sales say that Schedule A was actually on his computer?
Yes.
And then he says what it provided for, and that was 60% of the executive's salary?
Yes, as of 2005.
And
right?
that was and that's the relevant time period?
Yes.
Yeah.
Because what the agreement itself says, all three agreements. And Carl Coyle signed one of these agreements as well. And Michael Sales was a signator on that without, by the way, from what we've seen, a seal or a secretary. But they're dated 2004. The testimony alludes to the fact that they received these form agreements from an insurance broker in Syracuse because there was an intention that that they were going to write insurance for this, right? And then what happened was one of the folks one person said one of the folks at Liberty, another person said Paul Curtin. They came in and changed the names, the dates of hire, and things of that nature to accommodate the individuals that were going to sign, namely Elizabeth Nolan, Kim Pryor, and Carl Coyle. Okay, and after that was done, there's a question as to who signed when. But we know from the testimony of Paul Curtin that Carl had sent over to him the signed agreement of Kim Pryor in 2006. I believe it was in May, but the record would better reflect that. So there's some kind of dispute as exactly when. But Michael Sales, you're absolutely right. He had it on his computer. He was the one that made it. He, on behalf, as the president of the board of directors, made that Exhibit A. So he knows that existed. Now, where it is now, I guess we don't know. But
Not in a safety deposit box?
you know, that's a really good question. And I guess I should have asked that if they have other safety deposit boxes to.
Were there other agreements in that safety deposit
Yes.
box either?
Yes, they were.
Similar to this, these executive plan agreements, so were they getting?
It was for.
So I know Mr. Cole has one.
And Elizabeth Nolan.
Yes, she had one
and those were in there. The interesting aspect of that is who had access to that safety deposit box, right? And we know who had access to it. There were two people. One was Carl Coyle. And the other one was Kim Pryor. So those were the only two signatories on that safety deposit box. Right. So if this wasn't an agreement that they intended to do and intended to be bound by, like Michael Sales said in his testimony, in the record, he was very clear. In the record on 884, Sales believed the executive plan agreements to be binding on Liberty. And he wasn't talking about Liberty of Delaware. He was talking about Liberty of New York, right? So as it relates to the condition precedent, I do want to address that issue. Let me go back to what Judge Gilbert said. This agreement was not a model of clarity. If it was a model of clarity, it would have had the appropriate verbiage relative to a condition precedent. As we know, the courts in the state of New York do not favor conditions precedents unless it directly says that. The terminology that Mr. McMahon sets forth is just that. It doesn't exist in the agreement itself. It doesn't say if you don't comply with this, then you lose all your rights. That's not what it says. And that is what our position is relative to this.
Thank you, Counsel.
Thank you for your time and attention.
Not problems.
They bring their problems.
Case 11, Lillian C. versus State of New York.
There we go. Mr. Jamils, good morning, sir. Can you hear us okay?
Yes, I can. Can you hear me?
Yes, we can. Thank you very much. Mr. Williams, you're up, I think, sir. You don't mind, yeah.
May it please the court, my name is Steve Williams, and I've had the pleasure of representing Lillian and Stephanie Cervantes for 10 plus years in this matter. It's a very serious case, as your honors all know full well, this is an accident that stems from a highway design at the intersection of Burnett Ave and Collingwood Ave and the on-ramp to 690. Briefly, on the day of the accident, my clients were in a car traveling west on Burnett Ave. Burnett Ave had a through lane going straight west, and then it had a left turn lane that allowed people to turn left onto 690. Miss Lee was traveling east on Burnett. Miss Lee had a through lane, but she didn't have a left turn lane, which is very important because she intended to turn left. Instead, and for no reason ever explained by the state violated the highway design manual, and instead of putting in a turn left lane for those eastbound drivers to turn left onto Collingwood, they put in a concrete island and surrounded it with 2 yellow lines, indicating it would be a violation of the vehicle and traffic law to move over onto that island to gain a vision of oncoming traffic. This left Mrs. Lee in a situation where she couldn't see oncoming traffic through the vehicles waiting to turn left onto 690. And she had to cross 2 lanes to get across the intersection, the left turn lane and the through lane. On the day of the accident, Miss Lee approached the intersection slowly at a rate of 17 miles an hour. That's not in dispute. That's according to the event data recorder. She couldn't see if there was oncoming traffic because the cars stopped in that left turn lane on the other side of the intersection. So she veered to the right to try to see around them, and she felt that she had gained appropriate vision and the coast was clear. She proceeded through the intersection at 12 miles an hour, almost idle, careful. But what she didn't know was hiding between those 2 cars waiting to turn left on 690 at that exact moment of time was the car my clients were in, and a collision resulted. Now, the lower court decided that the state, in allowing this intersection to be designed like this and maintained like this for decades, created a damned if you do and a damned if you don't situation for Miss Lee. It put her in an untenable situation because she could not perceive oncoming traffic. Of course, I agree with the court. The lower court, however, I respectfully submit, considered some inadmissible evidence and perhaps misapprehended other evidence in determining that Miss Lee was 80% at fault for the accident because she did not yield the right of way for traffic she could not perceive. Further, the lower court's decision is inconsistent with the Court of Appeals decision in Brown versus State, which was a highway design case. And in that case, Mr. Friend came up to an intersection, looked for oncoming traffic. He did not see the motorcycle. He pulled out in front of the motorcycle and there was an accident and a death.
Mr. Williams?
Yes, sir.
Let me concentrate on your expert's testimony and how that might have harmed your client's case here. Okay. First of all, he claims that the intersection was safe when it was designed. It was the increase in traffic later on, correct? The evolution of the, whatever they made in a sandwich shop, be more Brooklyn Pickle got more customers and okay. And then the second thing is, despite that intersection that you're talking in the concrete barrier, had she been more careful, that the accident would have been, less likely to happen. And that could have been an issue at the lower court. What was your response to that?
Well, a couple of things. Our expert said it wasn't designed well, but he said it was not yet dangerous when it was designed because there was much less traffic, but it came more and more dangerous with time because the traffic through that intersection increased at a rate of 3% per year from 1974 to 2015. My expert, with all due respect, Judge, never said Miss Lee could have been more careful. He did not say that. He said she was left in an untenable situation. And in fact, both experts, the expert for the state and the expert, my expert, plaintiff's expert, said there is a decision point, a point upon which there is no return, where the driver is expected to make a decision whether to go or not go. And that's at the end of the island. And from that spot, Miss Lee could not see oncoming traffic. But let's talk about the new evidence that came out, because this court has looked at this case before. New evidence came out at trial that was very, very important. First, the state's highway design expert, who gave an affidavit to this court at the summary judgment motion stage, completely abandoned his affidavit and pretty much caved for the plaintiff. He admitted on cross-examination that the highway design manual states that it is critical, not just important, not just recommended, but that it is critical that intersections like this, where somebody has a permitted left turn, permitted being no stop sign, no stoplight, you don't have to stop, you go if nobody's coming. It is critical that a left turn lane be included. Defendant's expert agreed with me on that on cross-examination. And what's interesting about that is that language on that page of the highway design manual, the Bible on highway design, is actually bolded. No other language on that page is bolded. It is that important. And I invite your honors to look at it. It's at the record at 2646. So their expert agreed with me on that. Secondly, their expert agreed that the sight distance that's important is Miss Lee's vision of the oncoming lane. In his affidavit on summary judgment, the expert for the state said, well, the sight distance measurement is straight down Burnett, which doesn't make any sense. If somebody's turning left, why do they need to see straight down Burnett? And on cross-examination, he agreed and said, you're right, the correct sight distance is the distance looking in the oncoming lane, and there was no proper distance for that. What's even more important, however, the biggest change is when this court first reviewed this matter, there was an email exchange, and Justice Greenwood, you raised this during oral argument. There was an email exchange in February of 2012, 3.5 years before this accident. And it was between city officials, city transportation officials, and the Department of Transportation. And the city wrote to the DOT and said, hey, those turns from Burnett onto Collingwood, those left turns, should they be allowed? Shouldn't we prohibit those? And the state wrote back, well, people are encroaching on the island, so we're just going to leave it the way it is. And Justice Greenwood pointed out, well, that sounds like a question of fact as to whether the DOT was on notice of this very dangerous condition. Well, at trial, Mr. Jim French, who was the superintendent of traffic control for the city of Syracuse at the time, testified. And he said, oh, I know those emails. I was in on those emails. And you know what? I can tell you what prompted those emails. Those emails were February 22nd, 2012. He said on February 12th, 2012, I met with the DOT at the intersection and I expressed my concern. And I asked Mr. French, well, what was your concern? I told them that if somebody's trying to turn left onto South Collingwood, because that driver's offset to the right, and there's a turn lane on the other side of the intersection to the driver's left, and then an oncoming lane, that person trying to turn left can't see oncoming traffic, and it's going to cause an accident. He told them point blank. The state's only answer for that is, well, you know, Mr. French testified at a deposition and he didn't talk about that. Well, what the state doesn't tell you and what we told you in our briefs is those emails, those important emails had not yet been disclosed by the state at the time of Mr. French's deposition, so nobody had a reason to ask those questions. But we had him at trial and he told the state exactly the danger of this intersection, and still the state did nothing. In 2007, there was an engineering study for the building of the Brooklyn Pickle down the street, and it was provided to the state. And that engineering study said this intersection is failing. That's 2007. And the engineer said to the state needs to address this. This is 8 years before the accident. Still, the state did nothing. The rate of accidents for people turning left onto Collingwood versus people turning left to go on to 690, 200 times greater per car traveling through the intersection. This is notice to the state. This case is exactly on point with the Brown case, Brown versus State, the Court of Appeals case, where the Court of Appeals affirmed this court. Because in Brown, Mr. Friend, he pulled out in front of a motorcycle. He couldn't see it because of the design of the roadway. He was ticketed for failing to yield the right of way. The court said, we excuse that ticket. because of the negligence of the state. And what the Court of Appeals stated was, despite being confronted with the exact issue that caused this accident, the state did nothing. And for that reason, the state is 100% at fault for this accident, not Mr. Fred. And I respectfully submit that that case is spot on with this case. Miss Lee was as careful as she could possibly be. You have a question?
Well, I'm just going to say, your position that's in your brief is that the state should be 100% liable. The court's finding was the state was 20%.
Only 20%.
Right, and then, but there is testimony in the record that your client might have been inattentive, correct? I mean, that is the testimony.
Actually, Your Honor, that is not. Can you cite to me the line? Because
well,
I can say this, Judge.
Unless my record and notes are all wrong, but I think they are. I mean, I think there's testimony in there that says that she changed her mind. Didn't she change her mind?
Oh, I understand. I understand what you're talking about, Judge. Yes, sir. Yes, sir.
Okay.
A witness to the accident said as she approached the intersection, reducing from 17 to 12 miles an hour, she veered to the right and then went to the left.
Okay.
And she said, yes, that's what I did, because I couldn't see oncoming traffic through those cars waiting to turn left. So I veered to the right to try to gain a better perspective of the intersection.
Okay, so let's just stop there for a second. So let's just assume for argument's sake that that was a mistake. And so a reasonable court could have found her to be somewhat responsible based on that. So that's my question to you, that other than 100% state liability, do you have any other argument that, and it's not in your brief?
And I understand your point, Judge. And assuming that what she did was a mistake, perhaps you could argue that she may have been 1 or 2% at fault. But my response is this: it was not a mistake to try to gain as much vision as she could in an untenable, damned if you do, damned if you don't, voting in the lower court situation. She was forced into a situation, not of her own creating, an untenable situation, and she took reasonable precautions to deal with it. She slowed down. She tried to look around those cars she couldn't see, so she veered to the right to look. She thought she had the all clear. But in the shadows of those two cars was another approaching car. She did everything she was supposed to do, even more so. You know, it's interesting because Miss Lee, nobody knocked on her door 3.5 years before this accident and told her how dangerous this intersection is. Nobody knocked on her door 3.5 years before this accident and said, you're not going to be able to see oncoming cars at that intersection. And if you drive through it, somebody could get hurt, right? But the state had that information. They're the experts. They're the ones who have a duty under Weiss versus Foote to maintain this intersection and to continuously inspect it for how well it's performing under the actual traffic situation. And the state did nothing. If she had had that warning, she wouldn't even have been at that intersection. She did everything right. She slowed from 17 to 12 miles an hour. She tried to gain access, a better view. Now, what's interesting is the state's highway design expert, he said on the stand initially, well, she could have driven up onto the island to gain a better view. And I said, well, Mr. Highway Design Expert, isn't that island surrounded by 2 yellow lines? And he said, yes. I said, well, wouldn't it be a violation of the vehicle and traffic law, therefore, for her to drive up on that island? He said, you're right, I'm wrong. Change his testimony. He said, you're right, she could not have gone to the left. So when the state saw its case going down the drain, because its expert, its highway design expert, was agreeing with me, they decided to call another expert. And they wanted to have him testify as a highway design expert. This gentleman, Mr. Frost, is not a highway design expert. He was not disclosed as a highway design expert. He has an associate's degree in criminology, and I objected, but the court allowed it. And the court relied on this unqualified testimony in finding that Miss Lee was partially at fault. And what did the court rely on? Well, first, Mr. Frost said, well, you know, in my experience, 90% of accidents are human error. Therefore, this was probably Miss Lee's fault. Well, that's not proper evidence. His experience and these statistics he's pulling out of the thin blue air have nothing to do with the facts and circumstances of this case. I'd submit that was incorrect for the judge to rely on that statement. Secondly, the judge relied on Mr. Frost's testimony where he said, well, Miss Lee wasn't wearing her glasses. But the record shows, the testimony is She only needs to wear glasses during nighttime driving. This was a daytime accident. That is clear and unequivocal in the record. So for the judge to rely on that claim was improper and inconsistent with the proof in the record. And by the way, there are no glasses that would allow her to see through stopped cars. I mean, there are no X-ray vision goggles. I mean, she didn't need glasses, and even if she did, it has no bearing on this accident.
Mr. Williams, you should wrap up. Your time is up.
Yes, sir. Yes, sir. Mr. Frost opined that she could have moved farther into the intersection above the island, past the decision point, as agreed to by both experts. Both qualified highway design experts said, that's not a good idea. The closer you get to those cars on the other side waiting to turn left, less view you have, less sight vision down that oncoming lane. And Mr. Frost said he tried it days before the trial when the whole intersection had already been modified and a left turn lane was included. I respectfully submit that Ms. Lee was as careful as one can be in a completely untenable situation created by the state. And that in accordance with Brown versus State, where the state was confronted with the exact issue that caused this accident and did nothing, the state should be held 100% liable for this accident.
Thank you, counsel.
Thank you.
Counsel, Mr. Williams,
You still hear me?
you want to join us up here?
He's not here.
Yeah. Counsel, you want to proceed?
Yes, you can still hear me, right?
Yes.
I'm hoping. Okay, great. Well, may it please the court, good morning, Your Honor's own Demuth, for the respondent, state of New York. Our cross appeal and our opposition to claimant's appeal is based on one critical but fatal flaw in claimant's theory, and that is one that is nowhere supported by the trial record. And that is claimant's argument, which was their case in chief, which was a constant refrain that we heard at trial and in their briefs, was that on the day of the accident, Mrs. Lee was faced with a quote unquote continuous line of traffic from cars in the opposite lane turning onto Interstate 690 that was quote essentially unending unquote, and that she was boxed out by the continuous obstruction caused by motorists in this left turn lane. And there's a whole litany of quotes used both by claimant's counsel, and Mr. Surth, claimant's expert. But as we know, to hold a defendant liable in a case like this, you must base the proof on the actual conditions at the accident scene. And the actual evidence, and what the Court of Claims found, although we disagree with the apportionment, was that there was only one car, Mr. Udell's car, waiting to turn onto the I-690 on-ramp, and that it was Labor Day. Traffic was light because it was a holiday. So claimant's argument that she was boxed out and forced to wait, Mr. Surth said, oh, she's not going to sit and wait there forever. It's not what the facts show, because what the facts do show, and they're not disputed, not this particular one, Mrs. Lee never stopped or waited at all. She drove through the intersection without stopping or waiting until she could see oncoming westbound traffic, which again was temporarily obstructed by only one car. And even Mr. Surth admitted she could have stopped and waited. So claimant's whole case is built on assumptions about evidence that didn't exist. And I want to point the court, there's many, many quotes that support what they believe was the cause of this accident. But I want to point to one in particular in Mr. Surth. It's on pages 421 and 422. And that was him saying the intersection, in particular, this left turn that Ms. Lee was making was, quote, not a problem if there's not many vehicles making the left turn, unquote, onto the on-ramp. I think that more than anything shows how attenuated their theory is from the actual facts of this case. There was only one vehicle. To say that she was faultless because she couldn't bother to stop, to wait for this one vehicle to pass or to reach a point where she was comfortable, I think has no foundation. And so what did cause this accident? Well, Court of Claims, again, we disagree on the apportionment, but we fundamentally agree for the most part with the Court of Claims analysis there. It was Mrs. Lee's negligent operation of the vehicle. First, she never stopped while she was in this intersection. Nothing prevented her from doing so. Even claimant conceded that. She never decreased her speed below 12 miles per hour. Claimant tried to characterize this as a crawl, but I would submit that going between 12 and 17 miles per hour in an intersection when you're not yet sure if it's safe to turn is not a crawl. It's reckless. She even increased to 17 miles per hour, 2.5 seconds before the accident. She took her foot off the brake. She started to accelerate 1 second before the accident. Then she veered to the right And both Mr. Benito Dominguez and Mr. Udell thought she was turning right. And in fact, Mr. Udell thought she had a right turn blinker on, then accelerated and darted out while veering back to the left. Now, this wasn't because she had difficulty seeing. This was illogical, and that's the exact term used by the Court of Claims. This was illogical and more evidence of her bad judgment. Now, Mr. Frost, who is the state's expert, was the only witness to perform an actual accident reconstruction, testified that this accident was caused solely by Mrs. Lee's actions and her operation of the vehicle, and that the severity of the injuries were caused by this failure to stop or even to slow down. So the theory that we've heard from claimant in their briefs is that she was deprived of a decision point. It's just a red herring. She never gave herself the opportunity to get a decision point. She kept driving through 12 to 17 miles per hour. I think that is much more than a crawl, especially when you're not sure if it's safe to turn yet. And the fact that she couldn't see is also belied by her testimony. She acknowledged her deposition testimony that she was able to see what was around her. Nothing was taking her attention away from oncoming traffic. It was only till trial that she all of a sudden was assumed, or at least suggested that, yes, maybe the cars, again, one car in this turning lane stopped her from safely making a turn. I want to disagree with one thing about, there was no finding by the Court of Claims, and there was no evidence that DOT or the state ever violated the highway design manual, particularly the section dealing with left turn lanes. Yes, any highway could be made safer. Yes, that section says it's preferable. Yes, it's in bold, but there was no violation of the highway design manual because there is certainly no requirement in this manual or elsewhere that requires that you must have a left turn lane at every single intersection. I believe that's really all I want to say. I mean, our appeal is that the liability should really be zero for the state. But if the court were to disagree, there's certainly more than enough here to support what the Court of Claims did.
Thank you, counsel.
Thank you.
We're going to take case number 15, Haggerty versus Klein, MD.
May it please the court. My name is Richard Valentine. I represent John Haggerty in this action. I want to start with my argument in that I made a mistake in this case, a mistake that had a consequence, the consequence being that one of the medical providers in a list of 17 defendants, as listed in the summons and complaint, was not served timely. And consequently, the case against him personally and individually is in jeopardy from my mistake. The alternative that I'm relying on is a doctrine called the relation back doctrine. It is a situation where, despite mistakes by counsel in
But not
timely
mistakes
serving.
in serving,
I beg your pardon?
not mistakes in failing to serve somebody. That's not a mistake that the relation back doctrine applies to. It applies to things where perhaps you have the wrong defendant in that. or
Well, I think
such
that
as
the determination of the mistake and what it is a determination of, is that something that was not intended by counsel? And because it was not intended, it had consequences. And in this instance, the consequence is that he's able to avoid personal liability, but his conduct is still part and parcel of the case, in the fact that there are other defendants with whom he is aligned, both in terms of agency and ostensible agency and those types of relationships, and also in the decision of the Maduba court, where those medical providers in an emergency department share in liability and are responsible vicariously for the actions of members of the medical team. So, I mean, there is a situation here where the conduct of Dr. Boaz remains an issue of fact in the case, irrespective of whether he's a named defendant or not.
In the doctor that was named in the complaint, that certainly gave the other defendants notice that he was a target defendant in your complaint, correct?
Yes.
So they were aware of that.
Yes, that's true.
Right? And so they can't be prejudiced in terms of this is a new party to this action that we were unaware of and time has lapsed and blah, blah, blah. The focus, I think, is that the doctor is taking the position, am I not correct, in saying that he was out of state. He had moved out of state. He had never been served with these papers. He had no notice of these papers. And as a result, he wasn't in a position to respond, to move to dismiss, to protect his interests.
Well, Your Honor, that could, as a matter of fact, be true. But at the same time, that doesn't mean that his corporation that he was working for in California, that was doing business with the Kaleida Health and with Great Lakes Radiology, they may very well have gotten full notice of it. He's talking about personally having heard about it. I can't take issue with
that's why we have personal service on these things, right? You want him personally held in as a defendant in this case, which requires service within 120 days if you don't seek extension.
Yeah, and clearly he wasn't served. But the relation back doctrine is an exclusion to bar the plaintiff from taking any further action.
And that's really what we have to decide. We have to decide
Exactly.
whether or not the relation back doctrine applies to this particular set of facts.
Exactly.
Which involves service as opposed to, say, you don't include the right defendant's name on the complaint, that you meant somebody else, and you want to relate back, everybody had noticed, that kind of thing.
Yeah, but the statute doesn't have a specific type of mistake that limits the effect of application.
And you want us to include this mistake in that because the statute isn't defining, here's the only mistakes this applies to.
That's my position. And my position really boils down to two introductory phrases or precursors to the decision by the Court of Appeals in the revision of the relation back doctrine. The first paragraph that I would reference to is where they say, "We now hold." That indicates that it changes the previous interpretation of this statute. And what they say is the relation back doctrine is not limited to cases where the amending party's omission results from doubts regarding any of the party's status. The question arises from the reference in the statute to excusable mistakes. Excusable mistakes is something that developed over time in interpretation of the relation back doctrine. What the Court of Appeals describes in the depth of its review of the doctrine was that they now hold that this notion of an excusable mistake is being acceptable and makes it possible to rely on the relation doctrine, no longer has to be excusable. Any mistake is a mistake that can be taken into account, and the relation back doctrine will be permissible despite that mistake. The other time they say it is where they say, as we now make clear, we are changing this statute. We're not depending on showing that it was that there had to be something that was an excusable mistake, but we're taking that word out of the statute for all intents and purposes. That's the third prong of the relation back doctrine. Now, it's important to listen or to review and to recognize that this is an extraordinary doctrine. It does, in fact, permit a mistake that otherwise would limit
We're gonna have to look at that very carefully and see if this falls within the,
Well, I just would urge, first of all, that in the pre-Nemeth world, there were a relation back doctrine cases that permitted changes. And largely they were in medical malpractice cases. Because there are two conditions precedent before you get to the third the third bracket of this three-part doctrine. The first one is you have to have the same identical facts of the case involving the absent party as part of a condition with others with whom they share responsibility. Secondly, they have to be united in interest, and the united in interest analysis is something that basically determines that the non-participating party is tied into the actual conduct that was at issue for all of the members of the team. And because he is a member of that team and is involved in the actual actions affecting the plaintiff, that is a situation that is in many ways unique in other forms of personal injury practice and other types of areas where there aren't all that many instances where you have multiple people with the same transactions and occurrences identical, and you also have united in interest multiple parties that are also responsible and share responsibility in vicarious liability claims. And we've set forth in the complaint that there were multiple defendants who were vicariously liable, united in interest, because of their participation in what transpired during this patient's hospitalization.
Counsel, I think we have your argument. We'll take a hard look at it.
Okay, thank you.
If it pleases the court, I'm Brian Suter on behalf of Dr. Boaz. The argument put forward by plaintiff's counsel, appellant's counsel, presupposes the application of the relation back doctrine to this case. Dr. Boaz was named as a defendant right from the get-go. I get the relation back doctrine. It's a fair doctrine to allow an addition of a party that maybe nobody knew about. Most importantly, maybe the plaintiff's attorney didn't know about. He was named as a defendant. He was just not served. I got to stop calling the commencement by filing statute a new statute because, as I learned, it's been over 25 years. But if you were to allow this to proceed, you can name a party, not serve them. You're now abrogating the impact of the 120 days.
And there was no motion made to extend that time period, correct?
Nothing. No, Your Honor.
Was there an amended complaint too?
There was, and the amended complaint made no changes to any of the allegations about the Dr. Boaz. As we know, sometimes the relation back doctrine can apply to existing parties if the claim is amended. Oh, now we have a new claim against the party. That's not what happened here. Thank you, Your Honor.
Thank you, counsel.
Next case for argument is number 14. This is Smith versus Azzarella. The presiding justice is recused on this matter. Good morning. Are you Ms. Smith?
Yes, sir, I am.
Your long wait is over. The podium is yours.
Thank you. If it may please the court. I'm Deborah Smith. I'm representing myself pro se in a matter of an enforcement petition that was filed in New York State Supreme Court in order to enforce the unequivocal mandate of the Honorable Mary L. Sliz to secure the terms of the court-appointed or the court-approved separation and property settlement agreement, which was intended to dissolve a marriage that was debt-free to the defendant. The defendant
Ms. Smith, did you ever get the property back? Was it,
I
ultimately
did.
it was, I think maybe even
It took
recently?
5 years.
5
Yes,
years
it
ago.
took
It's
5
been a
years in
long
order
time
for-
ago that the order was put in effect though, correct?
It took 5 years for me to get the deed. I
Mhm.
don't have the other terms and conditions that were in the property and separation agreement based on the order of Judge Sedita. I would like to show the court something just for a second. I'll try to keep this blessedly, I will keep this blessedly short for everybody. There wasn't one list. There were about 12 lists. And the lists were endless. I tried very hard.
That's the list of the personal property apparently?
That's the personal property.
Did it seem to be changing, throughout the proceedings? I mean.
Throughout the proceedings, it changed constantly. It just was list after list after list. And then there were eBay pictures and the referee ended up becoming very frustrated with good reason in this case. The court did appoint a referee, and I was very grateful that they did because it seemed as if it would be difficult to have my side heard based on the
I think that was Mr. Tronelone, was that right?
problems. Yes, I had Mr. Tronelone, yes.
Yeah, he was the referee, okay.
I'm sorry?
He was the referee or?
He was the court-appointed referee.
Right. Mhm.
Yes, sir. He has since passed. I wasn't sure if the court was aware of that.
Sure.
Lovely man.
Yep.
Absolutely lovely man. The court came to the attention, I'm sorry, I said that poorly. The attorney that I hired to represent my portion of the case, for some odd reason, did not respond to the cross motion. I have no idea why. To this day, I don't know why. I believe there was concern that the property was not related to the petition of the plaintiff, myself. So he didn't follow through with the request. Everything's pretty much laid out in the virtual proceedings transcript, where Judge Sedita says that the attorney was not cooperative with the court. He missed deadlines, he missed appointments. He didn't even respond to the cross motion, which leads me to the one point where I felt that I did not have good representation, but I didn't know it until after I read the virtual proceedings transcript. The court ended up making a summary judgment based on the lack of information that they said was in front of them. However, what little the attorney did provide was key in this case because it was a prima facie rebuttal where Joseph Moscato, the plaintiff attorney, said she sent everything she could find to him. And that was the truth. But Judge Sedita stated that I stonewalled and didn't, but there were pictures, receipts, schedule of when I sent the things that Mr. Tronelone saw. And in Mr. Tronelone's report, you'll see that he mentions the volume. There's things on this list that are there's thousands of items. Unfortunately, I believe that the defendant had some difficulty with accumulating things. I did everything I could to appease him for 2.5 years before. I sought the assistance of the court in order to help relieve me of the difficulty of having the defendant abide by the court order. After all my efforts were exhausted was when I hired the attorney.
And Ms. Smith, just so you know,
Sir.
We've all read the briefs, we read the record, we're going to continue to do so as we contemplate our decision. So, you've given us extensive briefs, so you're welcome to continue speaking if you'd like, but I want to let you know the court is very familiar with the arguments you've made, and we'll give them thorough consideration, I can promise you that.
Your Honor, thank you so much. In summary then, I would like to say that it was unfortunate that Judge Sedita offered this defendant the opportunity to redeem himself by providing a court order that asked him to cooperate with the referee, because as you can see from the very last final letter of the referee, the defendant provided him a receipt for items that were not what they were represented to be. So in effect, he even violated Judge Sedita's order. I do want to say that across this nation, we're confronted with similar temperament. I'm asking this honorable body to find an avenue to a just decision. I can see that many revisions have been made to those domestic relations law in an attempt to relieve the court of these cases. And it's just unfortunate that it didn't transpire in a time that I was able to utilize them. But I want to thank you so much. You guys have had a pretty packed calendar, and you've been really great about.
No, you waited your turn. We wanted to make sure we gave you a good listen, Ms. Smith. And as I said, I assure you, we're looking at the record brief. We're going to do the best we can.
Thank you, Judge Sine. I really appreciate your help. Your Honor Smith, Your Honor Montour, Your Honor Greenwood, thank you so much for hearing my case today.
Thank you. We're going to deem the matter submitted. Thank you.